Network. And today we are fortunate to have with us Carrie Garber Siegrist. She's an associate with the law firm of Faegre Drinker in Washington, D.C. She advises nonprofit tax-exempt organizations on tax and corporate structuring, compliance, and transactional matters. Her tax-exempt clients include public charities, trade and professional organizations, social welfare organizations, advocacy and issue groups, education organizations, and private foundations. She also advises clients on lobbying activity, compliance, and engaging in the political process. I wanted to let everyone know before we start that if you take your cursor down to the bottom of the screen, you'll see some icons near the bottom. Among those are a Q&A button. If you click on that, a panel will pop up, which you can type your questions. Feel free to submit those anytime, and we will get to them as soon as we can. With that, I'll hand it over to Carrie.
Thank you, Andrea, and welcome everyone. We're excited to talk with you about a couple of legal options here for operating in and outside of the U.S. So let's advance to our next slide. Well, so there we are. There's Andrea. There's me. Thank you for joining us in what is, could be deemed modified nap time with pandemic-related work from home situations, and I hope everyone's doing well. But let's dig in anyway on the topic that I think is on a bunch of people's minds as we think about how we're able to help. Next slide. So what we're going to do today is go through the two legal frameworks that we mentioned, Friends of Organizations and Fiscal Sponsorships, after we ground ourselves in some of the basics related to tax-exempt organizations, and in particular, tax-exempt organizations operating internationally. We're going to save some time at the end for questions and answers, and we look forward to getting those questions from you. But if you have an urgent question, or you think one that would benefit the group before the end of our discussion on these issues, please feel free to share that. We have our colleagues prepared to review those and share them so that we can keep this a session that is focused on some of the things that are keeping you focused on this issue in particular. Next slide. So let's ground ourselves in what we're going to be doing today and the landscape in which we're going to be doing it. And that's primarily considering federal tax law. And I say that because there are a lot of pieces, lots of different rules and regulations that are applicable to organizations, both exempt and non-exempt, when they start to operate, not just beyond the borders of their state of incorporation, but beyond the borders of the country. And if you're a tax-exempt organization, then one of the key considerations is, what are the rules that relate to my federal tax-exempt status? So next slide, please. So I like to use this as kind of a waterfall flow down to understand where we're situated in the world, both as to legal structure and tax status. So for those of you who I've bored before with discussions, you might recognize this, but it's helpful as we think about the applicability of the rules that Andrea and I are going to really get into today. And so when we think about the nonprofit sector here in the US or even abroad, the next line down is the type of legal entity. This is the structure that you are. This is the corporate or not corporate structure. And I've made the biggest one on each row where we're kind of flowing down to. So we're thinking about nonprofit corporations. And honestly, in the context of our conversation today, your legal entity doesn't matter so much, but it's important to understand what it is we're thinking about and talking about. Because when we talk about fiscal sponsorships, for example, we're going to talk potentially about an individual or a project, not a nonprofit corporation. From there, in addition to being legally formed as a nonprofit corporation in whatever state the entity is incorporated in, we're talking about federally tax-exempt organizations that are recognized under our Internal Revenue Code, Section 501c3. So I just hopped down 3 steps there. We're thinking about 501c3 organizations, and particularly about public charities, though we will split into the land of private foundations a bit to talk about how in some of the requirements related to international grant making, the rules are enhanced for private foundations, creating more restrictions for those types of entities. So that everyone's on the same page, we're talking about nonprofit corporations that are recognized at the federal level as tax exempt as primarily public charities, but we'll touch on private foundations. And when we do, I'll be sure to note that that's specifically related to private foundation rules. Next slide. So what does all of that say? What does this mean for an organization that's recognized as tax exempt at the federal level? Keep in mind that that is one type of tax exemption. Some people refer to nonprofit organizations and think that that term is analogous to a federal tax exempt status. That's not necessarily true. Those are two separate things. And for the context of our conversation, the rules that we're applying here derive from the fact that the organization has opted into being recognized as tax exempt at the federal level under Section 501c3. 501c3 is one of the more restrictive tax exempt statuses available in our federal tax laws in the United States. And that's important for a variety of reasons and derives primarily from the fact that we recognize contributions to 501c3 organizations as deductible to their donors, whereas we don't for other types of tax exempt status, like a 501c4, for example. And so some of the things that we'll talk about in the context of grant making activities, you can certainly do from a nonprofit organization that's recognized under a different tax exempt status and might even have less restrictions than the ones that we're going to talk about today. So under 501c3, we're talking about a specific type of entity. That's that first bullet under C3 on our slides that engages in these types of activities listed in that second bullet. You'll notice there, and I like to call this out, that health and healthcare is not on there. We put health-related activities into the charitable bucket, and you might think, well, a lot of things fit into charitable, and you're absolutely correct. That third bullet under C3 is important for our purposes today. So no part of the net earnings of which inures to the benefit of any private shareholder or individual. In plain English, that means we're not going to be able to use the resources of an organization that's recognized as a tax-exempt charitable 501c3 organization to benefit a private individual in circumstances in which that's a substantial benefit and in which that individual wouldn't otherwise receive that as a charitable gift from the organization. And then that last part is very important. No substantial part of the activities, which is carrying on propaganda. I won't continue reading it. That's what we think of when we think of political activities and lobbying activities that are limited for lobbying and absolutely prohibited for a 501c3 to engage in as a recognized exempt organization. Next slide, please. So when we think about that exact language from Section 501c3 of the Internal Revenue Code, what that tells us is what kind of entity we need to be in, what activities we're allowed to pursue, how we may not or may use our resources, and the role that we can play in advocating and lobbying and the prohibition on our ability to engage in certain political activities. That's a great way to think and build your foundation to think about, okay, so one, what can that type of entity do here and outside of the US? Generally, if an organization that's tax exempt as a C3 in the US can do that activity, at least as to US tax law, it may also do that abroad. And I put in parentheses there, not local laws, because in some circumstances, for example, you might be allowed to engage in a limited amount of lobbying in the United States as an organization, and in another country, I won't name any, but I'm sure you can think of a couple right off the top of your head, a nonprofit organization coming from outside of that country to engage in lobbying activities as they would define lobbying under their local law would be absolutely prohibited. So again, generally, what you can do here as a tax-exempt organization, you may do abroad with a very large caveat of check the local laws. Similarly, what you may not do here, you may not do there, again, as to federal tax laws. So when we think about a U.S. tax-exempt organization being used, formed, or otherwise seeking to support activities that are outside of the United States, we think in the context of federal tax law, what it is we're allowed to do here as opposed to there. But we also then think, okay, so what are the rules as to my relationship and engagement with entities outside of the US? And I've listed some things here that we won't get into, but I just like to say, check the local listing and make sure that you're not qualifying to do business by engaging in a certain grant-making activity in a country, that you're not becoming an employer in that country by engaging in the activity. Lots of things to consider when you step outside of the border. Again, focusing on the federal tax rules, let's talk about then our forming a Friends of organization US. Next slide, please. So when we think about how an organization or group of people that are interested in working in the United States, collecting contributions and sharing those contributions for charitable, educational, or other permissible purposes outside of the United States, there's a lot of individuals, entities, et cetera, interested in doing that. And to reap the benefits that our federal tax laws allow for donors to receive or have recognized deductible contributions to those entities, that entity must be recognized and meet the requirements of being a 501c3 organization. So there's a bunch of different ways for those parties to engage in the U.S. The first is to establish a new organization, or it can make contributions, it can solicit contributions, and then other arrangements that we'll talk about, including perhaps fiscal sponsorship. When we think about working with an organization or a group of individuals who are outside of the U.S. who want to engage in this charitable space in the U.S., a couple of things come to mind before we jump into let's form a Friends of organization, which I promise I'll define in a little bit. The first is, how long are you going to be in the United States? Is this a huge fundraiser related to a catastrophe that the organization is seeking to solicit contributions from U.S. donors? That would be a very short period of time, hopefully, and for those who are victims of the catastrophe, it's short. Or are you looking to engage in a longer term way and perhaps engage in activities, not just fundraising, of course, activities in the United States in furtherance of your purposes? How much control do you want to exercise over that organization? Will you have the bandwidth to meet the administrative requirements for maintaining that United States organization? And importantly for our purposes today, what is your interest level and your ability to maintain proper corporate separation between the individuals or entity forming the U.S. charity and the U.S. charity? And those are the types of questions that on the front end I found have been most useful in getting to the answer of whether or not an entity or an individual is a good fit for forming a Friends of organization in the long term. Of course, the other option is considering fiscal sponsorship or other arrangements so that a new entity is not what is created. Next slide, please. So let's talk about Friends of organizations. Next slide, please. A Friends of organization is one of those types of entities that I get called about most frequently, where there's a lot of misunderstandings about what they are, what they can do, and whether or not they're actually a 501c3 organization. So let's build on what we've done so far and say a Friends of organization is really just a nickname for a type of 501c3 charitable organization, organized, operated in the United States that may do work abroad. And most people think of these organizations as perhaps a quote fundraising arm or extension of a foreign organization. But for federal tax purposes, we're not going to give in to that easy analogy and say this is an independent 501c3 organization formed by individuals who, or a group outside of the U.S. that might have an interest in operating in the U.S., soliciting funds, engaging in public education related to admission, et cetera, but is a separate entity. One of the most common reasons, of course, that you would consider forming a Friends of organization is to, expand your contributor base. And by that I mean by creating an entity that incorporates as a nonprofit corporation, seeks recognition as a tax-exempt entity under 501c3, it then is allowed to receive contributions from a variety of donors that are also deductible. So by having that entity, assuming it qualifies as a public charity, you now are much more attractive to some of our large private foundation donors who are looking to give and who need to meet the requirements for distributing their own assets annually, primarily to public charities. So it sounds really good. It sounds like a great option to a lot of people to say, wow, if we form this and we operate this type of entity in the US, we can tap into a potential set of resources that will really help us meet our goals. And I will say, absolutely, but let's understand some of the rules and the structures that are required to make sure you do so in a manner that's compliant. Because the things we're not talking about, the very large elephants that we're not talking about today, that also come into play here are when you do that, when you engage in that type of formation and operation of activity, a whole host of other US laws then are triggered as something with which that organization needs to comply. And I'll just say a couple of them. We're thinking about anti-terrorism rules. We're thinking about compliance with any OFAC-related sanctions or executive orders, and a host of other things that you'll want to make sure that the U.S. organization is equipped and ready to comply with. In fact, from the most frequent responses that I can almost count on in response to an application for tax-exempt status for a new Friends of Organization from the IRS, and reviewing these applications is, will you comply with all U.S. rules and regulations related to anti-terrorist measures, including checking the SDN list and all OFAC-related rules? It's almost like clockwork. So it's something to think about when you're thinking about creating this organization. Beyond what we're talking about today, but it's good to be aware of it. So the reason you, of course, form this Friends of Organization is because you'd like to be able to have donors have their contributions recognized as deductible. If you engage in certain activities in your operations in a particular way, and they're not structured carefully, and essentially you're basically a conduit for funds from the U.S. donors to a foreign organization that itself is not recognized as a 501c3, those donations may not be deductible, and indeed may expose the foreign organization or individuals who founded the Friends of Organization to more harm than the organization was ever worth, including reputationally. So what is allowed? You're operating a 501c3 organization, ideally that's recognized as a public charity under one of the two public charity categories that I think are most applicable here under 509A1 or 2. And you're operating to make contributions and grants to foreign organizations for purposes that meet your own baked into your formation documents tax-exempt purposes. This is so that the entity acts and is in fact its own separate entity. Next slide, please. Which leads us beautifully into discretion and control of Friends of Organizations. So discretion and control is a phrase that now you're going to become remarkably sick of hearing anyone ever say again, because we're going to really dig into this one. In order for a U.S. tax-exempt organization's activities to not result in no deductibility of the contributions from its donors, it needs to act as an independent organization that exercises discretion and control over the funds it receives. It may not act as a conduit. What does that mean? Essentially, let's talk about a very common scenario. A foreign organization says, I'd like to receive contributions to the United States, forms a Friends of Organization, and starts collecting contributions from individuals who believe in the work that that organization is doing. And the Friends of Organization board is constituted by individuals who are all, or mostly perhaps even, on the foreign organizations board. They hold perfunctory meetings if they hold them at all. And funds once received by the Friends of Organization are in a haphazard and poorly documented fashion with no clear indication as to what the funds are being used for, transferred to the foreign organization. Now, if you've been following along, you'll know that every single one of those things creates probably worst case scenario for the Friends of Organization that I just described, but they're all elements of demonstrating to the Internal Revenue Service, for example, that you are not exercising discretion and control. And so when we think about what does an independent Friends of Organization look like, we structure its governance, its operations, It's grant making within the confines of what we call discretion and control. Relating back to, if the money comes to the Friends of Organization, it needs to meaningfully stop there. It needs for the Friends of Organization to say, we are going to use the resources we've received for these purposes and make that decision on its own. If the Friends of Organization, for example, receives a call from a donor and says, I would like to give you $2 million and I want you to do these things with it, sounds great, fits within your purposes, you do a quick SDN check, the individual looks like they're a reputable donor, you run through your due diligence on the donor, this sounds good, you take a next step even, and the board says, yes, that sounds great, let's do it. But then when you get to the grant agreement stage, the individual says, hand you a grant agreement that says, and 90% of these funds are going to go to foreign organization. That's where you stop and you say, wait a second, I'm entering into a contract that tells me where to send these funds, and unless my board has reviewed and approved this, we're not operating with discretion and control over these funds. We're literally kind of a stop on the funds way outside of the United States, and the purpose of that stop typically is for some sort of tax advantage to be conferred to the donor. Otherwise, the donor would just make the contribution directly to the foreign organization. So this is where we say the organization, in a couple of different ways, exercises discretion and control over the funds. First, in its grant-making activities, but then also in its board composition. So when I say control and board considerations, that's what I'm thinking of. Is the board independent of the organization, the foreign organization, or the potential grant recipient from the organization? Are they making decisions that are in the interest of furthering the U.S. Friends of Organization's purposes? And that's a hard question to answer, because theoretically, and actually in reality most often, the purposes of both organizations are aligned. And so it almost feels as though it's a false dichotomy to say that our purposes are contrary to those of the foreign organization. But it's important to take that extra step and say, is this something that this organization, this U.S. organization, will approve of? And then we document it in that grant agreement, which we'll talk about a little bit more in a bit. Next slide, please. So when we're talking about maintaining discretion and control, these are the factors that I want to be in the forefront of your mind when you say, okay, if I'm forming a Friends of Organization, am I okay doing all of these things? The first on the solicitation is, you're not going to go out and say, I'm raising funds for foreign organization X. Please write the check to U.S. organization X. Do not make representations to your potential donors that you are collecting donations on behalf of a foreign organization. Right, by now that should trigger in your mind, yes, that would not be me exercising discretion and control. That's me literally operating as a volunteer fundraiser for a foreign organization. We mentioned board composition. Less than a majority of your board and your Friends of Organization should overlap with the board of your foreign organization. And there's some interesting conversations in the practitioner space about how much room there is here. But there's a couple of creative ways, depending on your state of incorporation, to think about how a foreign organization may exercise what could be akin to control without having even more than one seat on the board, for example, the Friends of Organization. And so if that's something you're struggling with, where the foreign organization says, I'm not particularly interested in this structure because it could go rogue, for example, there are ways through cost sharing agreements, affiliation agreements, licensing agreements to create circumstances in which activities of Friends of Organization are in some ways controlled to be kept in line with the charitable or educational or other purposes that you as the foreign organization have formed the Friends of Organization without violating our tax rules. Other options include committees, using a membership structure in your corporate governance, or even providing an ex officio board member from your foreign organization, for example, certain veto rights as to activities that the U.S. organization might engage in. And here I'm thinking, substantial corporate transactions like shutting down or granting a majority of assets to a particular organization. The use of grant funds. So did the organization agree with the foreign organization in advance how things would be used? And if so, did they actually make a decision to do that or not? And then do you have grant agreements documenting how you've decided to use the funds of the U.S. Friends of Organization? Interestingly, if you look at rulings in this space from the IRS that disqualify most often that whether or not a contribution is deductible, and then therefore the tax exempt status of the organization that received it, a lack of grant agreements is not a good factor in your favor if you're the Friends of Organization. A good example is an organization, like I described earlier, that sends funds at whim, it seems, to the foreign organization, or when, for example, the Friends of Organization's bank account to a certain level, just a tranche of funds would be sent over. That's not maintaining discretion and control. Next slide, please. So if we want to engage in international grant making in a way that will not jeopardize the tax exempt status of the organization that we are operating from, assuming that's what we've done, and we call it a Friends of Organization, if a gift is earmarked, it's on that conduit train, if you will, then it's not going to be either deductible or a proper gift to the 501c3 organization. The 501c3 at that point is not operating with discretion and control over the funds. If essentially the donor is controlling how the funds will be used, and those funds, like I said earlier, just stop in the 501c3 for purposes of having that contribution be deductible to the donor. And you might think, oh, obviously that's very obvious. Why would anyone even bother? You'd be surprised how many donors think that it is perfectly okay to have contributions stop as long as they continue to exercise control over it, even after it's been made to the 501c3, and then say it has to go to the next place. Next slide, please. So when we're documenting our international grant making from a 501c3 public charity, and I say that deliberately, we're talking about public charities again here, because the requirements for private foundations are enhanced, and we'll talk about those. We want to make sure that we've got a grant agreement in place. And for many organizations that I work with, their initial response is, I have to enter into a new grant agreement every time I want to send funds to foreign organization X to perform this program that we've been supporting their work on for years. The answer is yes-ish. What we want to do is create a master grant agreement. You want a paper trail that evidences that your 501c3 did exercise that discretion and control. And quite frankly, the simplest way to do it is to document it in a grant agreement, and then every time you transfer funds, provide an attachment how much was transferred, why it was transferred, when it was transferred, and any other additional terms or requirements that apply to the use and grant of that group of funds, in addition to the terms in the master grant agreement. And your master grant agreement is going to include all those things that you normally would in a 501c3's grant agreement, including that it's only going to be used for permissible tax exempt purposes, that there'll be some sort of reporting mechanism, though for public charities, it's not necessarily required, some sort of reporting mechanism back to the grantor organization as to what was done with the funds that were received. And in many cases, I recommend some sort of return requirement if the funds are not used in a way to further the purposes that are agreed upon. And most importantly, for example, if the funds are used in a way or in an activity that jeopardizes the 501c3 organization's tax exempt status. Here I'm thinking of those rules that we referenced in the very beginning. So if the funds were used and certainly shouldn't have been used, for example, to support or oppose a candidate for public office, then I like to see that there's some language in there that the funds have to be returned from the receiving organization to the US 501c3. No, that does not mean you need to chase them down to the end of the earth and never give up the fight until you get the funds back. We can talk about what's reasonable in seeking those funds another time. But it is a good step to have in your grant agreement, demonstrating that you understand that funds that are used from your organization cannot just skirt the rules of 501c3 by being granted out to an organization without you saying they have to be used for particular purposes. At the bottom there, I mention whether or not an organization itself, a recipient, would qualify as a 501c3 or under a tax treaty. This is important to think about in the context of where you're making your grants and to which organizations. A tax treaty between the U.S. and that country might exist and might be helpful to consult if you are working through foreign grant making. Next slide, please. So we've spent a lot of time on Friends of Organizations, and so I think we're going to get through fiscal sponsorships in a more expeditious fashion so that we can get to your questions and the answers to those questions. So let's get to the next slide and talk about, well, what is a fiscal sponsorship? And I'll start with the operating assumption that when we're thinking about fiscal sponsorship in this context, we're thinking about fiscal sponsorship not necessarily in the sense of a comprehensive fiscal sponsorship, which is a relationship where a project is entirely managed and a program of the fiscal sponsor, but rather a project-specific grant relationship between one entity and another entity for purposes of engaging in international grant making, which is our focus today. In other words, when you commonly hear fiscal sponsorship, you might be thinking of a different thing than what we're thinking through today, or as a use of fiscal sponsorship. It's not where you have a project that's kind of in incubation stage and is considering becoming its own separate organization, although that can certainly happen in this case. That is, in my mind, what we call a comprehensive fiscal sponsorship, and this is a grant-specific relationship fiscal sponsorship. So what is this? This is just a vehicle for granting funds from a U.S. entity to a non-501c3 organization that may either be prohibited or result in significant risk to the grant-making organization. And so when we think about this fiscal sponsorship relationship, it's a fiscal sponsorship relationship rather than just a grant agreement that results in another grant agreement to another organization for a variety of reasons that we'll cover, with the ultimate goal of understanding that this type of relationship results in potentially significant risk to the grant-making organization, that initial grant-making organization, that funder, before it's even made. So when we think about international grant making and you're not a public charity, it's possible if you are a private foundation to engage in international grant making, but you will have to do one of two things: either exercise expenditure responsibility over the grant, or make an equivalency determination. Both of these are more onerous requirements than you'd otherwise like to engage in, and you can avoid some of them by making a grant to a recognized public charity instead of exercising what I call ED or ER in this case. The most important part of the rest of the conversation as to fiscal sponsorship that I want to make sure we get correct off the front end now is that we're talking about three parties here. The first is a U.S. charitable organization that's acting as an initial grant maker. The next is a U.S. charitable organization that's acting as the fiscal sponsor, not comprehensively, but in a grant relationship, and a potential foreign organization that's the grantee project. And that can be an entity, individual, whatever it is, but those are the three layers we're talking about here. Next slide, please. So what was expenditure responsibility and what is an equivalency determination? These are rules that I want you to be familiar with, and if you would like some extra reading, take a look at Internal Revenue Code section 4945 that allows a private foundation to engage in grant-making activities outside of the United States and in some cases to organizations or entities inside the United States that would otherwise constitute what we call taxable expenditures to the private foundation, unless they do one of two things: exercise that expenditure responsibility or make an equivalency determination. Our program is not designed to fit in the requirements for each of those today, but just know that there are requirements and specific items to check off as you go through each of those processes, and they're not insubstantial. They require extensive record-keeping requirements from the grant-making organization, particularly if it's a private foundation, or if it's a foreign organization that would ultimately receive the funds. And I list there a couple of considerations for making the decision as to whether to exercise expenditure responsibility versus making an ED. Generally speaking, if you're going to have a brief one-to-one or even 2 or 3 time relationship, depending on the scope of or scale of your grant to that organization, it's probably easier to exercise expenditure responsibility than to make an equivalency determination. Next slide. So assuming that we're not going to engage in one of those 2 options, another option is structuring that fiscal sponsorship. And in this arrangement, we've got those 3 tiers that we talked about earlier, where the initial recipient, in this case, the fiscal sponsor, is recognized by the IRS. It has a determination letter as to its public charity status, and importantly, is not a private foundation. That matters because if you make that the fiscal sponsor a private foundation, even if you yourself as the original grantor are a private foundation or a public charity, then the private foundation fiscal sponsor will still have to engage in exercising expenditure responsibility or making an equivalency determination, making fiscal sponsorship kind of a moot point. So it's important that that first recipient is a public charity. And I like to say to clients that they make sure that there's conditions as to that relationship where the fiscal sponsorship relationship terminates immediately or promptly if that fiscal sponsor loses that public charity status, and that there's a requirement to notify the grantor if that status is in threat in any way. So then the funding goes from the initial recipient, our fiscal sponsor, the board of that organization, by operating discretion and control, says, yes, this furthers our own charitable and otherwise exempt purposes, and we would like to enter into an agreement with the grantor here that stipulates how we're going to use the funds and how we're going to select and control the next recipient of funding, if any. The overlap between what we talked about earlier with friends of organizations and fiscal sponsorship here is the same rules that apply to a friends of public charity apply here for your fiscal sponsor. We can't skirt them as a fiscal sponsor by saying, well, we're a fiscal sponsor. No, you're still a 501c3 first, and you need to make sure that whatever it is that you're doing furthers your tax exempt purposes and that you've approved it. If you don't, periodically the compliance failure from the fiscal sponsorship relationship can fall onto the grantor. So if you're getting pushback as a potential fiscal sponsor, it's helpful to explain, well, it seems like you're passing off the potential liabilities here to me, but in fact, they can return to you too as the original grantor. There is a look back here. Next slide, please. And this is when we think about earmarking. So earmarking, when we've got a charitable organization that's making a grant to a public charity, here our fiscal sponsor, which is earmarked for payment to a foreign organization, it is essentially treated as a grant directly to that ultimate recipient by that charitable organization. Why do we care about that? Because if you were trying to engage in a grant-making scheme that essentially skirted your responsibilities as a private foundation to engage in making an equivalency determination or exercising expenditure responsibility, and you've earmarked your contribution to your quote fiscal sponsor, not a real fiscal sponsor here, if they're not actually doing their job to exercise that discretion and control, then you're actually making that grant directly to a foreign organization, and you haven't complied with federal tax rules to do so. So a grant is earmarked when you've got that initial recipient, here your fiscal sponsor, entering into a contractual arrangement, typically, that obliges it to make that grant then to a foreign organization. And it doesn't matter if it's oral or written. There's no winking, there's no nodding here. There should not be an understanding that this is essentially money that we're funneling through you to a foreign organization. That's not how this works. They can have a mutual expectation that the initial recipient will transfer it to another organization, foreign or not. but there cannot be a legal requirement or obligation on the initial recipient, the fiscal sponsor, to send it to a foreign organization. Next slide, please. So when we think about how we document a fiscal sponsorship relationship in this context, I say in this context because when we think about fiscal sponsorship, a comprehensive fiscal sponsorship agreement is going to be much more comprehensive, in a word, than your fiscal sponsorship agreement for the use or the making of a grant in these circumstances. So keep that in mind as you look at or consider options as to how to engage in this type of arrangement. But the most important thing you're going to have is how the funds are going to be used. Here, the grantee is going to use the grant funds only for the purposes that are set out in the grant agreement. And there typically is some sort of proposal or summary or otherwise programmatic piece that you can attach and incorporate into that grant agreement as an exhibit, which is a great way to show the rest of the world who might be scrutinizing this, hopefully not the Internal Revenue Service, but if it is, a great way to show them that this relationship started because we were furthering these specific purposes as evidenced by these defined activities. In addition to saying we're doing the right thing with this money, it's also helpful to say, and we will not do these other things that we know you, grantor and grantee, depending on who your fiscal sponsor is, are prohibited for you to do. And so here I say we're not going to engage in influencing legislation or the outcome of any public election. Particularly focus on legislation bit for a second, what we otherwise call lobbying, because your grantor is likely a private foundation and we don't want to otherwise have a taxable expenditure related to that activity. Or to engage in any activity other than what's defined in the project, as defined in the scope that you might attach as an exhibit. A good practice, some say it's stronger than a good practice, is to have the amount of the grant kept in a separate fund dedicated to the project. Does that mean a separate account? Oftentimes, yes, if that's something that is not an Everest hurdle to overcome for the recipient, that's the safest way to document and show how those funds are safe and secure and used only for the purposes that are provided for in the grant agreement. Next slide, please. So this slide provides a couple of terms that we thought we'd get into the weeds just for a moment here when you're creating the fiscal sponsorship agreement, because there is some often confusion as to whether or not there can be a mutual expectation that funds go, or whether or not that really is an earmarked grant. And so we've provided in the slides today for you some language to help you document these relationships and understand them better. I won't read them out here, but what we're hoping to very clearly lay out in whatever arrangements between the initial recipient, the fiscal sponsor, and the grantor are here. And that for these purposes, the funds are transferred, complete, full gift from the grantor to the initial recipient, here, the fiscal sponsor. And that's critical. We cannot have the organization making the grant continue to exercise any control over it if we're going to say that it is a completed gift. That third bullet, though, is where you can say, we also think that it's probably a good idea if the grantee receiving these funds uses them to fund the sponsored organization. And you can define sponsored organization, as you see above in that first bullet, as an organization that is equipped and prepared and otherwise vetted to further the purposes that are identified. That fourth bullet has the key terms that you'll want to consider and include, which, if they're not actually true, you can't really rely on them. So not only are they helpful as to you're reminding you what the requirements are, but also to making sure those requirements are actually complied with. First, that it's not earmarked, that the grantor is not going to exercise discretion and control over the selection of the next recipient, if there is any, or even of the sponsor organization. The grantee isn't required to disperse any of the funds to any particular organization, and may otherwise use the funds to further its purposes. In exchange for all of that, of course, the grantee typically may withhold a certain amount of the total grant value as a fiscal sponsorship fee, that is perfectly permissible, because essentially the grantor is using the advantageous tax status of the fiscal sponsor to accomplish its goals without having to operate its own public charity. So it's fair compensation. Next slide, please. So that covers what we had set as our particular content. And so let's open it up and see if we have some questions.
Thanks so much, Carrie. We have had quite a few questions come in, so I'll take them in the order they were received. The first says, if a donor or private foundation wants to fund a UK charity, but decides to go through a US nonprofit organization, 501c3, what are the legal obligations of each of the three parties in terms of who they need to report to, carry out due diligence on, et cetera? Would that be stipulated in the grant agreement?
Can you give me the first part of that again? What's our flow here? It's a UK organization?
The private foundation wants to fund a UK charity via a US 501c3. So the ultimate beneficiary of the money, the expectation of the ultimate beneficiary of the money would be a charity in the UK. So they want to know who's responsible for reporting, who's responsible for carrying out due diligence, et cetera.
Right. Well, so all those particulars you'd lay out between your fiscal sponsorship agreement between the U.S. private foundation and the U.S. public charity or charitable organization that would receive the funds, with those terms that we just looked at in particular, saying, you know, the sponsored organization in this case is probably the UK charity, but the recipient is not under any obligation, of course. We're not earmarking it for the UK charity. And the obligation for that private foundation to engage in reporting still remains with the private foundation as to, for example, its federal reporting requirements. So they can't dodge having to report where their funds go or where their funds were used for, or whether or not they should evaluate if the distribution of those funds meets their distribution requirement, for example, by engaging in this type of arrangement. So you'd want the reporting obligations between the private foundation to the U.S. public charity, from the U.S. public charity to the private foundation to flow down between the relationship with a sponsored organization from the public charity, so you get the information that you need to report back for each entity.
Great. The next question, there's actually two from the same viewer, but I will break them up. So the first is, some friends of organizations do indicate solicitation for a particular charity. The example given is Friends of the British Museum. Is this a problem?
So this is a fun question, because this is akin in my mind to sitting down with a client who I say, well, you cannot engage in that activity. That is prohibited political support or opposition to a candidate for public office. And if you'd like to do that, we're going to run it out of your affiliated 501c4, or we're going to set up a 501c4 for you to do that. And they say, well, I just saw XYZ take out a full page ad in the Washington Post for or against such and such candidate. That can't, so it has to be okay. Well, so it's not a perfect analogy, but what I'm getting at is it is perfectly fine for an organization in the U.S., a charitable organization, to exist to, even in name, to support a foreign organization, as long as the funds that are received by that U.S. organization are controlled by the U.S. organization. We see this most often with friends of groups for alumni of a university in a different country, or a museum in another country. That's perfectly fine. What we need to do is not have it be a conduit, though. We can't have the development office of foreign university X saying to Friends of University X organization in the U.S., okay, send us everything you have now. We're going to create this XYZ program. It has to be a standalone entity. If you exist to support one foreign organization, as long as that otherwise furthers permissible tax-exempt purposes, have at it as long as your organization has, pulls the final lever that says this is where we're sending these funds.
The next question is somewhat related. It says, I've seen a number of U.S. and U.K. charities that have completely overlapping boards. I've been told by U.S. counsel this is acceptable as long as the U.S. entity's board has discretion and control over the funds. Is that an accurate statement?
These are great questions. So this is, like I said when I was talking through this issue, this continues to be an area that there's debate within practitioners as to what's permissible. You'll see a range of actual operations of how this plays out. Some of them have access to legal counsel and some don't care. Some take their cues from other organizations and say we're going to do this. We are as plain an organization supporting as plain an organization, non-controversial organization as you could possibly find. The likelihood we're going to get in trouble is really low. But as your lawyer, I'd never say that's the analysis you should make. You should say, okay, so what are the rules and how are we complying with them? Within the risk matrix we've identified as what applies to our organization. And then what we do have is guidance from the Internal Revenue Service that one of the factors that indicates that you do not exercise discretion and control is a majority or complete overlapping board. I have colleagues who say, actually, that seems to indicate to me that they will be in complete alignment in furthering their purposes because they have overlapping boards, but that will not be the position that our friends at the IRS take if they're scrutinizing the relationship.
Great. And the next question seems to relate back to the original question we had about who's responsible for taking care of due diligence, et cetera. It says, just to add a bit more clarity to the previous question, if there is no formal relationship between the three organizations, board representation or otherwise, what are the implications of this approach, and would that fall under a fiscal sponsorship? I need to look back. Let's see. Oh, I think they were just trying to clarify what they were asking, but I think you answered that in a very robust way, so I think that has been answered. The next question says, are the rules different if the original donor is a U.S. individual, not a private foundation?
Are the rules different as to whether or not you can earmark a contribution?
I'm assuming, it doesn't say, but that would be my assumption.
Okay. Unfortunately, no, not if you want it to be a deductible contribution. So for you to take that deduction, you cannot then tell the U.S. organization how to spend those funds. It doesn't matter if you're a private foundation, public charity, or any other taxpayer. For you to have that tax advantage, that contribution, you can't be the one who stands in the shoes of the public charity and says this is where the money goes. If you'd like to do that, I'd encourage you to consider serving on the board of the organization. I know that many organizations are always looking for individuals willing and able to serve on their boards.
And then we had a couple of other questions come into the chat box. And let me see if I can find it now. How do these regulations change for a church denomination based in the U.S. giving support to international partners, NGOs or church bodies, to do humanitarian development or peace building work?
They don't really. So one of the things that confuses scholars and practitioners in other countries that practice in charity law, for example, in those countries, is that we lump in with our tax-exempt status for charitable and educational organizations, religious organizations. So without opening up the can of worms of separation of church and state that we try to ascribe to here in the U.S., and that we lump into tax exemption and provide, in effect, in some ways, a subsidy for religious organizations through deductible contributions and no federal tax paid. For these purposes, the rules still remain the same. If you're an organization that's in the U.S., that's a 501c3, with or without a determination letter, churches, and I say churches broadly within the definition of C3s, churches are religious organizations, still need to comply with those rules. The wrinkle here, of course, is that most churches don't file IRS Forms 990. There's other requirements that they are exempt from by virtue of the fact that they are religious organizations, and we have separation of church and state.
Great. Wow, questions just keep pouring in. This is terrific. Is there a similar...
Oh, no. Now we've lit a fire.
now someone is interested to know if there's a similar webinar or other resource available that outlines reporting, discretion, and control requirements for 501c3s acting as fiscal sponsors to U.S.-based organizations. In other words, where can I find more information about fiscal sponsorship relationships that are contained in the U.S.? Are you aware of an organization that provides resources on that, or a great book, or that's something that we could research?
Well, so Charity and Security Network, is that something that you guys have?
We have not produced any information on fiscal sponsorship relationships to date.
So that would be my first recommendation. If not, then there's lots of associations of nonprofits that exist that I would recommend you take a look at their websites. You know, there's the National Association of Nonprofits, there's a Council on Foundations. Some of these associations require membership in them. I tend to say that the return benefit of membership in those organizations is much higher than what you pay, particularly if you're operating on the edge of needing to access regular legal counsel. Those organizations often have resources that will get you as far as you can possibly go without needing to engage a lawyer. And sometimes that's really all you need. So I'd say consider looking at those resources. But the nonprofit sector, in particular the nonprofit bar, I think is very generous compared to the bars and other practice areas. We put out a lot of resources through a variety of different channels. You know, there are some firms that have substantial blogs that I would find reliable that you can take a look at on fiscal sponsorships. And then there's a seminal text on fiscal sponsorships by a member of the nonprofit bar, whose name I'm just going to quickly pull up, who in the last year published a new edition on fiscal sponsorship. Gregory Colvin's book, it's called Fiscal Sponsorship, 6 Ways to Do It Right, by Gregory Colvin, and the newest edition, that third edition by Stephanie Pettit, is comprehensive and is what at least lawyers consider the text to consider when you're thinking about these structures. That might be overkill, but it's worth taking a look if that's what you really want to spend your pandemic time reading about.
Some U.S. charities are the sole member of an overseas charity. In other words, they can appoint the board. Similarly, I have seen the IRS accept that an overseas charity can be the sole member of the U.S. charity. If the U.S. charity's board exercises discretion and control, I presume that this is an acceptable arrangement?
Yes, and here's the fun corporate angle or wrinkle as to why that what otherwise looks like a discretion and control scenario does work, at least as the guidance that the IRS has given us so far. When you've got a membership structure, remember, most people are helped in their thinking about a nonprofit that has members by the analogy that members are akin to shareholders in a for-profit. They have similar rights. Indeed, they can even sue derivatively the nonprofit if you're unlucky enough to experience that. But a member doesn't govern or have those fiduciary duties to the organization. So even though foreign organization X may be the sole member or even designate an individual to the board of U.S. Friends of Organization, they are not sitting in the seat of every single one of the directors, and almost every state but Delaware requires at least 3 directors. And it's rare that you'd get a determination letter from the IRS for an organization that has less than 3 directors on its board. So you're exercising discretion and control because your board, even though it's appointed by your foreign organization, they're still separate. For some reason, that separation is respected by the IRS.
Great, and it looks like we have time for one more question. This is in a friends of situation and a master agreement. What are the best and minimal practices needed for individual disbursements of funds? Does there need to be correspondence from the overseas recipient saying specifically in advance what they will be spending the money on? Or are there other arrangements that don't involve separate grant agreements?
The most comfortable I get in an arrangement where you're sending funds from a U.S. organization that's properly exercising discretion and control to a foreign organization without some sort of otherwise documentation, either to an attachment on a master grant agreement or even a separate agreement or proposal or email even. is in the context of if you've got a grant agreement and it provides an advance for lump payments over a certain period of time. So let's say you know you're going to transfer $1 million from U.S. organization to foreign organization X over the course of the year. Lay out every term that's applicable to every single one of those transfers in effectively what is like a master grant agreement at that point. And that those funds, even though they're transferred in multiple batches, instead of one lump payment, all still must be spent in furtherance of the specific purposes and under the obligations and rules laid out in that grant agreement. Otherwise, I'd say get a master grant agreement if you can't predict what and when and how you're going to be funding, and then document it. You don't need an exchange in writing first between the organizations, but the exhibit that I'd recommend you attach to your master grant agreement will specify the purposes for which those funds are being spent. And I will raise my eyebrows at you if you call me and say it's for general operating support to the foreign organization, and I will say you're walking too close to the line. Do you really want to get close there? I will stop there out of respect of our time, because otherwise I can keep talking about these things for a very, very long time. But I think I will call it a day.
Thank you so much, Carrie. This has been a super informative session, and your willingness to answer some of these advanced practice questions and curveballs that were thrown at you today is impressive. So thanks again for joining us. I want to let everyone who's listening know that we have recorded the session, and we will be posting the recording to our website in case you wanted to go back and listen to any portions of it. Thanks, everyone, and stay well.
Bye now. Thank you.